Good morning, Manishji. So, very good morning to all of you, and welcome to today's discussion on charitable trust. Basically, we all know that recently the Apex Court has given two important judgment, and a few days back we got another judgment from Pune Tribunal in case of a charitable trust. So there is a confusion which is going on. What activities can charitable trust do rather than instead of the activities, what price or fees they can charge or what they cannot charge, whether they should be markup, there should not be any markup. And I'm sure it has got great implication. And all of us, somewhere are connected to the charitable trust. Either we are member of a charitable trust, we have temples nearby us. We are linked to the education institutes who might be working as a charitable trust, or we may have our own charitable trust, or we might be the consultant or an auditor to the charitable trust. So somewhere I believe we all are connected directly or indirectly to the charitable trust. So in past we have done one session on this issue on the judgments of the Apex Court, and today we have my friend Somil to take us through those judgments. Though Somil do not need any introduction, but let me share his brief profile with all of you. He is a qualified chartered accountant and he is partner in the firm Messrs. RRA Legal, tax and economic law advisors and advocates. He is actively handles direct tax litigation and advisory. He is also associate member of ICSI and ICMAI. He also holds masters in commercial law from University of Brigham. He regularly appears before various benches of the Tribunal and the Honorable High Courts and the Supreme Court of India. He is regularly invited by various chambers and study circles to give lecture on tax-related topic. His articles on corporate tax issues have been published on iittatonline.org and journals of various professional entities. And we are lucky to have Somil today with us on this Sunday morning, which is pretty cold in India right now. Somil bhai, over to you. We all are eagerly waiting to hear you.
Thank you, Gaurav ji, for the kind words and blessings. Sunday morning, very good morning to all of you, respected seniors in the profession and my very dear professional colleagues. As Gaurav ji rightly said, the topic for today, the charitable institutions under lenses. It has been a while that these institutions, charitable institutions, organizations are being under the scanner, under the lenses. The paradigm shift in the registration process by introduction of 12AB, the introduction of provisos in 1023C, the way to some extent there has been misuse of these provisions, which are for the purpose of giving exemptions to the institutions doing charity, and which over a period of time, with a continuous process of abuse, misuse, to some extent, has brought these institutions under the lenses, and which has seen reactions across the board. Whenever, as councils, we argue in matters where we know that the perception is such that is already against the assessees, it becomes a more difficult task. And educational institutions, charitable institutions have been a matter of perception. There has been perception that too much fees is being charged, so much amount is being charged. There is no element of charity as such. And while we discuss these judgments and we go through them, one would see that to some extent, yes, the judgments are also influenced and have been driven by these perceptions. After all, honorable judges of the courts are also human beings. They're also listening to the news and everything. They're humans like you and us. The first decision, New Noble Educational Society from the Honorable Supreme Court. This judgment, Gauravji, was rendered in terms with respect to 1023C subclause 6. Now, section 10, we all know, provides exemption, provides that in case the requirements of the provision are fulfilled, then the income shall not be included in the total income. Clause 23C provides a list of various institutions which are, if conditions are fulfilled, the income would be exempt. And clause 6, subclause 6, any university or educational institution existing solely for the purpose of education and not for purpose of profit. So these three conditions, educational institution, solely existing for education and not for purpose of profit, which may be approved by the prescribed authority, and after the amendment by the Finance Act 22, the principal commissioner or commissioner shall be approved under 1023C6 and the income shall be exempt. I mean, this provision 1023C subclause 6, 1023C for that matter, it has about 24 provisos. And even while arguing, and those provisos are unnumbered. So even while arguing the matters, each time when we have to refer the provisos, one has to again, before the bench, my lords, bear with me, let us just count the provisos and then refer to that proviso. So New Noble, the issue before their lordships, this judgment, the underlying judgment was the judgment of Honorable Andhra Pradesh High Court, confirming the denial of registration under section 2023C6. So the issues involved were, what is the meaning of, or what is the interpretation of solely? Secondly, if there any surplus, any profit, how it has to be treated and what is the consequence of that? And third, very important, that in that case, the assessee had not complied with the registration which is required under the Andhra Pradesh Charities Act. So the compliance of any other law under state or local authorities, which is required to be complied with, if not complied with, what is the consequence? So Andhra Pradesh High Court had done against the assessee. They said the objects can only be educational. The compliance of other authorities, the registration in the other acts of the state is mandatory. And accordingly, the matter was before the Honorable Apex Court. So you would recall that the requirement that the compliance has to meet in respect of the other laws, state laws or local laws, that has been brought in the statute recently from 2021. However, in this case, though pertaining to the old regime, there was nothing in the law as such, and that is what the case of the assessee was, that the Income Tax Act does not require that the compliance of any other law is mandatory, and that is how the argument was given. So New Noble was in respect of specifically 1023C6. These were the issues involved. The first thing which the Honorable Court have, in fact, reiterated, I would say, is regarding what is education. Education, way back Constitution bench in 101 ITR page 234, Lok Shiksha Sansnan, Lok Shiksha Trust, 101 ITR 234, Honorable Supreme Court. The lordships held that education for the purpose of income tax means formal schooling, formalized schooling, giving knowledge, skill, for character for the by formal schooling. Education, though, can be read in a very wide sense. Even if somebody is traveling, one is learning. By reading newspapers, magazines, one is learning. But it was held that education for the purpose of income tax, for the purpose of this provision, cannot be read in that wide sense, and accordingly, the requirement of there being teachers and taught by way of formal schooling, the process of training and development of knowledge, skills, character through way of formal schooling is what was laid down in Lok Shiksha Trust, and accordingly that has been rightly reiterated in this judgment also. That is the Constitution bench judgment, and accordingly it had to be followed. So as far as education is concerned, the terminology, the meaning of that, the scope of that, that is what was laid down by Honorable Supreme Court in that judgment has been reiterated. Now the concern, the issue which came up was that, say, an education institution has objects which includes education, apart from that, say, other objects as well, say medical, hospital, though in the actual carrying out of activities they are only doing education. And in those lines, till now the law was laid down that predominant, the main purpose has to be seen. And once that was held as education, then there was no problem and registration should be granted. Honorable Supreme Court in Queen's Education, that the predominant object has to be seen, and if that is education, then registration has to be granted. Now here, 1023(6), two very important words have been, phrases have been emphasized. One, solely for the purpose of education, and the other, not for purpose of profit. The lordship have held that even the mere fact that objects include some other objects also, which is not education, though the assessee may not be carrying it out, still they would not be eligible for registration under section 1023(6). So the first takeaway which I would like to emphasize here is that solely has been given, has been read with a very literal meaning. Literal interpretation has been given. The lordships have devoted quite a discussion on that, and they've held that when the literal interpretation itself is clear, there is no ambiguity, then there is no scope of any further addition. And accordingly, the judgments of Queen Education, American Hotels, they have been overruled, and they have held that the objects can and should be solely and only in respect of education only. Any other object in the memorandum would render them ineligible for registration under section 1023(6) for the purpose of education. Interestingly, in para 51 of the judgment, now as Gaurav bhai you mentioned, charitable institutions 11, 12, and there has been a lot of confusion right now because some law has been laid down, important law has been laid down in New Noble. Other observations, important law has been laid down in Ahmedabad Urban Development Authority judgment. Now these two judgments operate in a very different area. That has to be, this is a very important aspect which has to be understood while appreciating these judgments. New Noble Education Society operates with respect to 1023C6. And over there, the phrases are solely for education and not for purpose of profit. On the other hand, Ahmedabad Urban Development Authority, it is in respect of the proviso to section 2, subsection 15, defining charitable purpose. The interpretation of 215, and it is in respect of the GPUs, the charitable institutions which are engaged in advancement of any other object of general public utility. So GPUs is what was the main focus in that judgment. So the two judgments operate in different areas. Yes, in respect of education, some observation of New Noble will definitely affect the education for the purpose of 215 as well. And as we'll discuss further, 11.4a has also been touched upon, though it was never the dispute, never the issue in New Noble. But still, the observations with respect to the 7th proviso of 1023C, which is pari materia, with 11.4a have also been made. Despite that, the court in para 51 have categorically held that in respect of 1023C, that in the case of latter, the basis of exemption in all these provisions, the positive condition solely for educational purposes and negative injunction and not for purposes of profit loom large as compulsive mandates necessary for exemption. So the differentiation, the difference between this provision and the GPU and 215 has been recognized in this judgment. So only to these specific observations which have been made in New Noble, like for 11.4 and others, or education, that to some extent can be made applicable to 215, but other observations, other aspects may not be made applicable in respect of 215. That is the important distinction which I wanted to highlight over here at the outset. Now, 1023C6, approval has to be taken from the authority. Honorable Supreme Court in American Hotels had held that at the stage of approval, and the law as we understood, that at this stage, the prescribed authority is required to only see the objects of the institution and the genuineness of the activities of the institution. Even we used to argue based on plethora of decisions that, sir, at the stage of registration, the authority is required to confine itself only to objects and genuineness of activities. And on these lines, Honorable Supreme Court in American Hotels had held that the issue of application, the generation of surplus, is a matter which has to be seen at the stage of assessment and not at the stage of application, approvals. Now, in respect of that, in this judgment, that issue was considered, and the lordship have held that the observations of American Hotels to the extent that they can apply to a new institution, yes, that is there, but there are cases where even the existing institution can apply for the registration, and therefore to confine the limits, the powers of the prescribing approving authority in respect of the registration would not be the correct interpretation of law. And they have held that in the course of registration itself, the approving authority can go through the accounts, can go through all these documents, and may call for any documents as deemed fit to examine. Ultimately, the main purpose is examine the genuineness of activities and objects of the institution. So by examining the accounts, the way activities are being carried out, the actual activities being carried out, the real purpose for which institution has been created, has been established, would come out, and accordingly they have held that the powers of the approving authority are wide enough to cover everything. Though they have also, there's an observation that the mere fact of surplus may not per se debar from registration. It is the holistic view which one has to take, and accordingly the primary object of the institution has to be analyzed, understood, and accordingly it has to be seen whether it is eligible for registration or not. To some extent, in view of the latest regime which has been brought out, in which initially the institution is established, is given provisional approval for some period, and subsequently final approval is being given. So earlier, since there was a fresh registration, there was no activity as such being carried out in many of the cases. That is why it came out that yes, you can see the application at the stage of assessment. But now in this new regime, that itself requires that, all right, you are provisionally approved. Not much examination is being done at the provisional stage. You carry out the activity, you claim exemption, and at the stage of final examination, final approval, all those activities can be now examined. So these wide powers which have now been interpreted, read into the powers of the prescribing authority, approving authority, seeing in the new provisions, I would say is pretty much in line with the new regime also, and seems to be that was also the object of the regime itself, and which has been now read by the Honorable Court itself. Therefore, the activities would be available, the application would be available, how much surplus, how profit is being worked out, how much is the SSC charging for the activities. So that whole analysis will now be available at the time of final approval, and accordingly, to my mind, these examinations, thorough examinations will be carried out, and accordingly one has to be very cautious at the time of filing of the approval for 1023-6. Now, sir, as I discussed a little while ago regarding the compliance of other laws. Now, this requirement, the court has held, it is not optional, it is mandatory. It was the AP Charities Act which was not complied with, and it was held that these institutions, these laws are made for the purpose of regulating these institutions, and for the purpose of reading into income tax also, for the purpose of registration, the compliance of these laws are mandatory. You would recall, sir, in the latest regime also, the requirement has been read into the provisions that compliance of any other law is mandatory, and that would be examined by the approving authority. Now, that amendment came from 2021. However, their lordships have categorically held that the compliance of any other law, state law, local authorities, whatever law is required, to which the institution is required to comply, is required to be complied with. Now, sir, another issue which has been dealt with is regarding the incidental activities. The lordships, while referring to the 7th proviso of section 1023C, which goes on to say that nothing provided in this provision will apply to the income from business and profession unless the business is incidental to the attainment of the object of the education trust and separate books of accounts are being maintained. And while discussing this proviso, specific observation and specific reference has also been made to section 11 subsection 4A, which is peri materia, which also provides that in respect of the business which is incidental, separate books of accounts have to be maintained. So the first purpose, solely for education, the objects can only have education. Now, as far as the not for purpose of profit is concerned, as I explained, the holistic view has to be taken. The mere fact that there is some surplus being generated does not per se bar from registration. In fact, if there is surplus after surplus in continuous years, then one may have problem that yes, the activities are such, coupled with other circumstantial evidences, obviously, seeing the accounts, seeing what is the fees being charged as compared to the arm's length price in the by other institutions. So all those factors have to be brought in. And accordingly, if it is seen that yes, the activities are being carried out for the purpose of profit, then there would not be any eligibility for the registration under 1023C6. So merely because there is surplus itself will not be a bar. But holistic, the overall conduct of the SSC will have to be examined. And as the wide powers have been read into in the powers of the approving authority, everything can be examined, any documents can be called for. And accordingly, he may take a view that yes, these are for the purpose of the objects, the activities are for the purpose of profit and not complying with the provision of 1023C6. So solely and not for the purpose of profit have been held that the institution has to exist and exist only for education. It is only at best incidental surplus that can be created. But if it is found on the basis of examination of facts, the conduct of the SSC, the activities of the SSC, and if it comes out that the activities are for the purpose of profit, then the registration will not be allowed. Now, coming to that incidental aspect, sir, I remember we had an occasion to argue the matter. Now, educational institutions, AICTE, the condition for registration itself with the AICTE requires that you have to have a hostel. So the issue arose that the activity of hostel, say for transportation of students, running of canteen or mess, so all or uniform, sale of textbooks, all these activities. The question arose whether 11.4a or for that matter, separate books have to be kept for that purpose. So by relying on the AICTE norms, that look, the very fact that AICTE gives permission only on that hostel is being maintained and many other conditions, itself goes on to show that these activities are integral part of the carrying out of education. And number of decisions came out that yes, this is integral part of education and part of the main activity. However, their lordships, referring to 1023C6 7th proviso as well as 11.4a being peri materia, have categorically held that these kind of activities hostel, transportation, canteen, mess, sale of books, all these will constitute incidental to the education and separate books of account are required to be maintained. They have further gone to hold, because there have been cases, say the auditoriums of the institutions, they are given out for other education, even given for education purposes to other educational institute to conduct workshops, to conduct seminars. It has been categorically held in para 73 of the judgment that these will not be made part of the educational activities of the institution. That such income will fall as other income in the other heads. So these activities will not be eligible for exemption. The scope, the limitation in respect of the incidental activities for educational institutions has been laid down. Even the incidental activities have been given by examples, transportation and all. And Gauravji, one very interesting aspect came to my mind, that we all, chartered accountant, company secretaries, we all give exams, have given exams. Exams are given in schools, educational institutions, and even if they're recovering the cost, charging nominal amount. Now, this example itself goes on to show that educational institute cannot give their infrastructure to the other education institute. This, to my mind, will pose problems here.
Somil, they cannot give, or they can give, but they will not get the exemption.
Yes, in fact, rather the very fact that they cannot give is can be a situation, because it is not only income which will not be, income definitely will not be exempt. That is because that is not from the educational activities as has been held by the Honorable Court. But if that activity, because the way solely for education has been emphasized in the judgment, so activity objects have to be very cautiously in the narrow compass of education only, to my mind, for the purpose of 2023 C6. Hostel facilities and all, they have been held as incidental. It is only that separate books of accounts have to be duly maintained. Yes. So, giving us brief sum up of the situation from new noble decision, education meaning, obviously, yes, it has been reiterated. Teachers and taught, formal schooling. The institution should exist only for education. The earlier position that dominant object, if it is education, it is all right, that has been overruled. It is only and only for education. And I'll reiterate at the cost of repetition that in the objects, even if there is some other object which is not education, and despite the fact that it is not being carried out actually, still the mere fact that an object is there in the memorandum will render it ineligible for the registration. So the objects can and only remain only for education itself in the objects clause. The institution should not be for the purpose of profit. Now, there has been no benchmark laid down what is the profit here, but it is the overall conduct which has to be seen. How activities are being carried out, what fees is being charged, and this wide power, as I said, has been already been given, read into the powers of the approving authority, and that is how overall it has to be seen, will be analyzed to see whether it is for the purpose of education solely and not for profit, or the circumstances, evidences, documents indicate that it is for the purpose of education. And Gaurav bhai, as you mentioned, the judgment of Honorable Hyderabad bench in Fernandez Foundation, latest judgment, that is the latest example how perception, how the observations made in this decision will impact and will go on to impact. In that case, Honorable Tribunal held that hefty profit is being earned, fees which is being charged is way more than the other institutions. The activities are being run on commercial basis. And on those lines, the Honorable Tribunal dismissed the appeal of the SSC, holding that the activities are not for are not solely for education and are for the purpose of profit. The compliance of any other law, which I
just
yeah.
So, I have seen many educational institutes, they do have some portion for a bank. You will find, banks are operating from school premises or from university premises, or they must have given, let's say, a small space for the ATM counter. And maybe, for some stationery shop. So they might not themselves involved in selling of books or selling of stationery, but they could have let out the property. And there are, not only the auditoriums, but you will find we take cricket grounds on rent, we take tennis courts on rent from the institutes, college institutes or the education. So what will happen to all this, Somil, now?
Gauravji, to my mind, if they are going in 1023(6), the way it has been interpreted, the way law has been laid out, it is in a very tight compass. 1112, to some extent, yes, there is scope. And for that, 11(4)(a) will come into play, incidental activities at best, and one has to maintain separate books. But 1023(6), by giving the example in para 73, very direct example, and that too for the purpose of education itself, seminars, workshops for other institutions, that also has been kept out of the educational activity of the institution.
Can we
And
take few
incidental
more
activity,
questions? Yeah.
and incidental activity, which has the way it has been interpreted and laid down, it has to be ultimately an attainment of the objects of the institution. So whatever activity one will be able to demonstrate that this is ultimately for attainment of my objects of education, then only that can be covered in this compass. If it is for merely earning surplus by renting it out using the assets, that to my mind is out of 1023(6). It may to some extent be used in 1112, but not here. That is why I pointed out the difference between the two also, judgments and the area in which they will operate.
So let's say, one takes the rent or, whatever the collection is coming and uses to discount a fee from a poor section. There could be in the institute, there could be two type of category, one who can pay
Right.
the fee, one who cannot pay the fee. So
Right.
in institute, I have developed a policy, whatever the rent I will collect, whatever the incidental charges I will collect, I'm going to use it for the education of poor people.
Right.
So now, can it be read that it is incidental to the education purpose?
Gaurav bhai, they have gone on to say that the application is irrelevant. What I understand in your example is what I generate, I apply for there. That has been read irrelevant.
Okay.
So my reading, obviously, I may be wrong, but to my reading, 1023(6) is very narrow right now. And especially in view of the example given, the activities, even the incidental activities have to be linked to the attainment of the educational object.
Yeah.
That is my understanding of the judgment.
So can we take few more questions, Somil bhai, with your permission from the
May I
audience?
just reiterate
sure.
couple of more takeaways, and then I will take up these issues.
Sure.
Even the observations vis-a-vis 1023(6), because which have been made the way in limitations, the way it has been held that if you want to have exemption, if you want to do exemption education, do only that. And the way this has been done, to my mind, this will also have effect on 1023(4) and other provisions where there are hospitals and medical institutions involved. Similar language has been used in the provisions, and this can also affect them also. Plus, as I said earlier, 11(4)(a), though was never the issue before the Honorable Court, but by specific reference to that, reading it peri materia to 1023(c) 7th proviso, the observations, the indications which have been made in this respect will also be applicable to 11(4)(a). And Gauravji, one very important aspect which comes is that how this judgment will operate. What about the pending appeals? Because there is a very interesting observation in para 7, the last para of the judgment, and I'll read for the benefit of everyone. This court is further of the opinion that since the present judgment has departed from previous rulings regarding the meaning of the term solely, in order to avoid disruption and to give time to the institutions likely to be affected to make appropriate changes and adjustments, it would be in larger interest of society that the present judgment operates hereafter. As a result, it is hereby directed that the law declared in the present judgment shall operate prospectively. Now, this is, to my mind, a very gray area. Right now, it has to be understood how it will affect come into effect prospectively, because whether the question is whether it will apply to the pending appeals. And Fernandez Foundation is one of the examples where the tribunal has followed New Noble and Ahmedabad Urban Development to hold that commercial activities are being done. Even their lordships in this judgment also have dismissed the appeal of the SSC against the Andhra Pradesh High Court. So, in what way prospective application is being made is something itself a question. One may expect, yes, no reopening would be done, no retrospective action would be taken, that is understood. But to my mind, all those issues where there is pendency, judgment would apply. And further, the very observation of the Honorable Court that we shall give, the time shall be made available to the institutions to make appropriate changes and effect be brought out. To my understanding, objects must be purely education, whatever amendment has to be brought is required to be brought. So to some extent, yes, time is also being given. But the law, to my mind, is applicable right from the day of the judgment, and the judgment itself overturning the judgment, dismissing the appeal of the SSC to the pending issues wherever there are in respect of the registration, this judgment will directly apply. That is my humble understanding. So the takeaway is that closely objects must be scrutinized. There should not be any element apart from education there. The surplus, if any, should be incidental. And year after year surplus may pose problem. Therefore, the way activities are conducted, carried out, the actions they conduct, the action of charity should be discernible from them. The other laws which are applicable should be complied with. And the scope of approving authority is wide enough. Everything can be called for to see whether it is for profit or actually educational activities are being carried out without any purpose of profit. And wherever there are incidental activities like transportation, hostels, and all these, separate books of accounts have to be maintained. So, Gaurav bhai, these are the issues which I could find from the judgment of New Noble Educational Society in respect of 1023(6) and wherever applicable. So, you want to take questions right away on this, or should I move forward for Ahmedabad Urban?
No. Let's take few questions. You know, if the participants have few questions, we can take hear it now. I would request friends who have joined us on a YouTube to please post their questions on the comment box, and we're going to take those questions. And friends who have joined on the YouTube, on the Zoom, you know, they have put in few questions on the chat box. Let me first take the questions available on the chat, and then you may raise your hand or unmute yourself, and we'll take quick questions. So we have a friend Manish ji who has joined us from Bangalore. His question is, in the example given by Gaurav, the bank is used for schools activities, also like collection of fees from students of that school. In that scenario, if any fees is collected from the bank, shouldn't be directly related to education activities. Somil ji, we'll take your comment, but Manish ji, I personally feel to collect a fee, you do not need a bank. You only need a bank account. Somil, what you have to say on this?
Very true, Gaurav ji. Collection of fees, you don't need a bank for that. I mean, and then the argument that from bank you are charging fees, to my mind, somebody would say it is a camouflage to give bank the property on rent and earning rent through that. And that may not find favor to my mind.
Now the next question is from Vinod Garg. His question is, what about if an education institute has an agriculture income and also income from vehicles to pick and leave the students from school to residence? I think about the vehicle, you said one needs to prepare a separate account.
That's the only requirement. 7th proviso. It has been what has been done is, earlier also we were having that. Earlier we were able to argue, and there were judgments that it is integral part of the activity, main activity. The only difference is now it has been held as incidental activity. Activity is permitted. There is no dispute on that. Transportation, hostel, canteen, everything is permissible. But yes, separate books have to be maintained.
And one will not get exemption on this income.
No, that is there.
That is there.
That is there because it is incidental, and it is only the requirement is because 7th proviso itself says nothing will apply unless it is incidental. So since it is incidental, it will apply. The provisions will apply. The only important requirement is separate books have to be maintained.
Somil, there is another case, and yesterday I have seen a fete was there in my kids' school. The school organized the fete. And I think most of the schools in Delhi, they do organize the fete. And they collect good sponsorship fee from that fete. So what about that fete income? Whether it should be considered as an incidental to the education, or it should not be considered as an incidental to the education, because those who are participating are the students. One may take an argument, that some functions are going on, we are giving them the public exposure, all this is part of learning. So bank, letting out to a bank may be a separate thing, but charging a sponsorship from a fate could be argued separately. What would be your take on this?
Gauravji, my view would be like, yes, if the activities involve only the students of the institution, then the activities are educational activities being run by the institution. Now, charging the hefty sponsorship, if it comes out that it is on commercial lines, you would see in the judgment of Fernandez Foundation, if it is not in line with what other institutes may charge, or what is the trade and practice in that regard, if it is way too enormous, then that will bring in the element of for the purpose of profit. Then that may pose problem. The activity itself for students, whatever activity you want to do for attainment of the objects of education, that would be permissible. That is not a problem. In this, if you invite other schools and everything that is going on, seeing the example there, if it is primarily for the purpose of students of the society institution, that to some extent may also work. But renting out for other institutions also, that has been excluded.
So what about the agriculture income if some education institute has got agriculture income?
Sir, agriculture income can be earned only if the objects allowed to agriculture. When the objects itself will say only education can be done, how can you earn agricultural income?
Okay, so we have...
And the other question that where to show an ITR, ultimately exemption is there. It is only your separate books during assessment or approving authority may require that have to be demonstrated that yes, separate books are being maintained.
Correct. We have another question from Kaushik ji. Let's take the question from Atul ji. Atul Puri ji,
sir.
A very senior member, sir is always regular to attend the session and give his blessings to us. Atul ji, over to you.
Thank you. Hi Somil, kaise ho beta?
Good sir. How are you, sir?
I'm doing well. Okay, now most of the educational institutions running medical colleges.
Yes, sir.
They have to have a hospital affiliation.
Yes, sir.
And most of them have their own hospital, which make a tremendous amount of profit.
Yes, sir.
What will be the status there?
Sir,
Books of course separately.
Yes. So primarily the activity would be medical college, the educational institution. The object is education. Now, like we used to argue in respect of hostels and transportation, that this is mandatory. When the law itself says that compliance of other laws are mandatory, when the hospital itself is mandatory, so we can argue that it is incidental to the carrying out of the attainment of objects of education.
Right.
Separate books have to be maintained. That is true. And in 1023C6, the only issue which I see here is respect to the enormous profit, if any, if it is derived continuously, then one may question that it is for the purpose of profit. So that is something which can come under lens, come under scanner. Apart from that, merely the hospital is being run because that is required by for the compliance of medical college itself. To my mind, that can be treated as attainment of as incidental to the objects of the education. So mere existence of hospital may not be a problem, but too much profit, despite the fact though separate books are maintained, there is no as such benchmark laid down over here. But as I said, sir, overall conduct will be seen, and if it is seen that it is primarily for profit through hospital, then that may pose problem. That is what I can say.
You said that in the case of it is not permitted, but will it impact the, suppose they're making profit? Because during COVID days, most
Yes,
of the
sir.
hospitals, they made tremendous profit. It was mind-boggling. They had
Yes,
never
sir.
expected it. Without any expenditure whatsoever, they were minting money. And will the cancellation of the registrant also be a case?
Sir, ultimately the test is solely for education and not for purpose of profit.
Mhm.
So by going through these accounts, by seeing the way hospitals have worked, so by seeing how the fees has been charged, and if there is enormous profit, again the same point, problem may arise that these institutions are running for profit. So I would say it is better to go into 11 and 12 than 10, 23 C6 in that situation.
Exactly. And the profit in any case will be taxed separately.
Yes.
There is no choice on that.
Yes, yes. So that would
Thanks.
be a better comfortable situation as compared to remaining in the litigation aspect here.
Absolutely, absolutely. Thanks, Beta. Thanks.
My
I
pleasure,
think,
sir.
Somil, we have taken a good break of questions. Now we can proceed further, and the balance question we can take after your this discussion.
Yes. In fact, with respect to Ahmedabad Development Authority, Gaurav ji, the judgment, as I submitted in my initial remarks, is regarding the interpretation, the purpose of proviso to section 215. And it is in respect of the institutions which are carrying out. Gaurav ji, chat screen नहीं हट रही मेरे पास से. How is that? All right, yeah. So the assessees, the associations which were in this decision were more of assessees carrying out the object of any other object of general public utility. You would recall that the first proviso to 215 is applicable in respect of the last limb of 215, that is any other object of general public utility. Now the issue arose that whether the activities carried out by, say, these development authorities, public created under the statute, even trade associations, educational professional institutes like ICAI and all, trade promotion associations, certifying authorities. So all these associations, institutions, organizations which are carrying out the activity of advancement of general public utility, are they hit by first proviso after the amendment in 2008, which provides that the activity of advancement of any other object of general public utility shall not be a charitable purpose if it involves any activity in the nature of trade, commerce, or business. So the argument, the issue arose that the activities itself resemble with the business, and therefore they all are hit by first proviso and not eligible for exemption under 11 and 12. So that was the primary issue before their lordships in Ahmedabad Urban Development in 215, the first proviso, the applicability interpretation of it, and whether these institutions which are carrying out these activities, are they hit by first proviso, and whether can they be said to be part of GPU or not. That was the issue before them. After a detailed analysis, their lordships have held that GPU, the activity of general public utility, even if it may resemble the nature of business, trade, or commerce, for that matter, say town planning, development authorities, and all these, still, since they are made under a specific law by the statute, they are regulated, and whatever fee charges they are recovering allowed by the law, and these are necessary to recover their cost, and therefore these are the activities, this is the surplus which is created in the carrying out of their very object of attainment of general public utility. And therefore, they are not hit by the first proviso to 215. Since the very activity itself is a general public utility object, GPU object, therefore, they're outside, they're not hit by first proviso to 215. However, if they carry out some activity which is in the nature of business, which is in the nature of trade, commerce, then the limitations, quantitative limitations laid down in 215 proviso, that the receipts, such receipts should not exceed 20% of the total receipts, will be required to be adhered to. And again, the fact that the amount which is generated is ploughed back, the surplus which is generated is ploughed back into the very same activity, that factor again has been held irrelevant. So the general public utility objects, yes, they may resemble it, but if they are earning only nominal marginal markup and the primary activity is primarily carrying out the attainment of GPU object, then it will not be taken as business. If they carry out any other business, then 11.4a would be required to be adhered to, separate books have to be maintained, and the first proviso and the will have to be complied with. That 20% limit has to be complied with, and in the earlier years, respectively, 10 lakh, 25 lakh, whatever the limit was, that has to be complied with. Now, Gauravji, very interestingly, in this judgment, where the GPU activity has been accepted as not for the purpose of business, on the lines that the activity is carried out on cost to cost basis or nominally above cost, cannot be considered to be trade, commerce or business. So nominal markup, nominal profit is acceptable, and that has been reiterated number of times, that to this extent, if it is there, then there should not be any problem. And in such situations, the GPUs shall not be hit by first proviso and shall be allowed exemption under section 11 and 12. Now, in context of these GPUs, while discussing the illustrations of incidental activities, very interestingly, the lordships have held that providing access to low cost hostel to weaker segments of society, where fee or charge recovered covers the cost plus nominal markup, or renting marriage halls for low amounts, again with a fee meant to cover cost, or blood bank services, again with a fee to cover cost, are not activities in nature of business. So GPUs 11-12 have been given a comparatively broader area, I would say, and the examples that we were kind of discussing, that creating surplus using idle assets, if any, so that would be treated as incidental business. Separate books of accounts have to be maintained, but that is to some extent that is permissible with the GPU activities that has been laid down in this judgment. I'll read it at the cost of repetition that the discussion regarding Ahmedabad Development Authorities, its law, is more in regard to the last limb of 215, read with the first proviso. So business, these activities of trade associations, development authorities, public authorities for the purpose of public development, town planning, all those activities which are development authorities, even ICI, professional conduct, professional institutions, trade promotion activities, they all have been held as carrying out the object of advancement of general public utility. Even, however, the caution which has been laid in all the situations is that where during the assessment, if the assessing officer finds that the charges which are being levied, the amount which is being recovered is leading to high margins, then he may examine which activities, which businesses, which are they incidental, or what exactly is being done. And if it is in the incidental activities, then yes, the 11.4a and first proviso have to be complied with. That 20% limit has to be complied with, and separate books of accounts have to be prepared, maintained. Mere fact that there is some surplus while carrying out the GPU object will not debar from exemption. So receipts from such activities, higher amounts are charged, then that should not exceed the 215 proviso limit. (11.4a) as has been read, incidental activities that have been covered. So such institutions, even if say renting out the auditorium halls or giving the Gaurav, as you said, cricket grounds for matches or whatever other activities, separate books being maintained and 20% cap has to be adhered to. That is the requirement in respect of these institutions. Apart from that, all these objects being public purpose objects and functions for the development, all these authorities, they have been held as GPU and there is no dispute on that. Only the cricket associations, they have been sent back to the assessing officer to examine for further examination in respect of the observations made by the court. And in view of that, to my mind, that Gaurav primarily sums up what exactly has happened in this GPU situation. So all those development authorities, educational institutes, professional institutes, trademark promotion institutions, they all have been allowed exemptions subject to compliance of 11.4a, and if there is any incidental business, then proviso has to be adhered to. The issue interpreting the proviso saying that the very activity itself is business has been rejected, and it has been held that the GPUs, the organizations, are merely recovering cost and made under a specific statute set to the authority, and therefore, since the very object itself is an object of general public utility, they will not be treated as business. They will not. They may resemble nature of trade, commerce, or business. Still, they are falling under GPU and will be allowed exemption. With this, Gaurav, to my mind, I have completed my deliberation, and any further questions, I would love to take them.
I think in a very simple manner, you have shared the facts and the judgment of the Honorable Court. So let me take few questions which are already there in my chat box, and I will request friends if you have any question. Yes, Somil, you want to say something?
Gaurav, one point also I want to emphasize, though it has no direct effect right now, but that may have, is a very important deliberation has been made on 11.4 and 11.4a. 11.4, business undertaking can be held as property under trust by a charitable institution. And 11.1, the property held under trust, income derived from that is eligible for exemption. So a very thin line difference has been created to my mind between 11.4 and 4a. 11.4 is where the business itself is settled in the trust by the donor or by the settler during the creation of the trust, then it is the property held under trust, and that has been made eligible for the purpose of exemption. However, the GPU in this context, carrying out business on any business being carried out by the GPU or on behalf of GPU itself, that has been laid down as incidental activity under 11.4a. Their separate books have to be maintained and first proviso will have to be complied with. Not more than 20% receipts can be accumulated there. So this is a very interesting differentiation which has been created. Business is being allowed, but that business should be a property held under trust. Now, how this differentiation, how this business segmentation unfolds, that is something we'll see in future. That is what interesting aspect I wanted to submit, because in such, to my mind, in such kind of GPUs, because 11.4 says the assessment of 11.4 business would be made as per normal provisions of PGBP, and any addition or any income found there will not be treated as being applied for the purpose of charitable purpose. So at one point, the judgment has held that these activities are not business. So as far as they are concerned, that activity is safe. But in respect of the business which are held under trust, 11.4, a good deliberation has been made. So how things unfold from here is something we'll have to watch out. Gaurav bhai, over to you. You're on mute.
We have one question from Ashish Bajaj. He asked the question earlier, whether the existing trust, I think that was on 2010-23-6, which we were discussing, whether the existing trust covering all charitable activities have to convert their activities in any way. So what is the implication, Somil? I think, are you there, Somil? Somil bhai, are you there? I think there is some signal issue at the end of Somil ji. I think these judgments will going to have a far-reaching implication. Vinod ji, would you like to say something, Vinod Garg ji?
Yes, sir. Sir, if for transportation we maintain a separate books of accounts, whether installment paid on buses, loan for buses extra will included in the application of fund of the trust main books.
Sir, I think we have lost Somil. वो भी चले गए हैं. He would be joining back, but what I can gather from the discussion that there needs to be a separate books for this transportation, and it would be seen as the incidental activity. तो separate books बनानी पड़ेंगी. उसको बनाने के बाद आपको merge करना नहीं करना. Let Somil join us. Probably Somil would be better person.
जो लोन की इंस्टॉलमेंट हमने दी है वो एप्लीकेशन में इंक्लूड होंगी या नहीं होंगी?
सर वो तो उसको सेपरेट बुक से बना देंगे उसका. अतुल जी, आपका क्या व्यू है? अतुल जी.
सर मेरा ये व्यू है कि जब उसकी बुक सेपरेट बनेगी तो उसका प्रॉफिट निकालने से पहले उसके अगेंस्ट जो इंटरेस्ट वगैरह वो निकलेगा.
वो सर बिजनेस एक्सपेंडिचर हो गया, क्योंकि
10+ आएगा ना.
नहीं वो तो ठीक है सर, लेकिन जो इंस्टॉलमेंट हमने पे की है वो जो लॉन्ग टर्म लोन लिए हुए हमने वो एप्लीकेशन में लेते हैं हम. नॉर्मली आज तक हम एप्लीकेशन ऑफ ट्रस्ट लेते हैं.
Purchase of capital asset is always taken as application of funds, right? Depreciation मिल जाती है.
लेकिन वो सेपरेट बुक्स हो गई तो वो.
So now we have Somil ji with us. Somil ji, the question which is going on, Vinod ji ने पूछा है. This question is कि जो हम buses operate कर रहे हैं schools में, one must have taken a loan to buy those buses, purchase those buses.
Yes.
So one must be paying the interest.
Yes.
And installment.
So
yes.
Whether that interest and installment should be seen as a उसको किस तरीके से will going to take care?
Whether it will be part of application of fund of the trust or not, when separate books of accounts are maintained, whether the installment paid will be part of the application of fund of the main trust, main books of accounts.
Sir, in fact, now since these activities have been held as incidental business under 11.4A, so these would be treated as an independent activity under business. They are allowed to be carried out. So the assessment, to my mind, of these activities would be carried out as per business provisions under PGBP. So whatever allowances, like this is direct expenditure for the purpose of business, that you have taken a loan and interest has been incurred for that, so that will be allowed as expense. As far as application is concerned, since it is no more as part of the integral activity, main activity of the education or the charitable activity, it will not be taken as application.
सर आज तक तो हम मतलब कि जो बसों के वगैरह ट्रांसपोर्टेशन के लोन लिए हैं उनकी जो इंस्टॉलमेंट पे की है वो एप्लीकेशन ऑफ फंड्स में लेते हैं.
सर वो इसलिए इसी बेस पे लेते थे ना कि ये तो इंटीग्रल मेन एक्टिविटी है हमारी, बट अब जजमेंट में ये इसका कॉन्सिक्वेंस है.
ये तो बड़ी मुश्किल हो जाएगी, क्योंकि जो कि ट्रस्ट, मेन ट्रस्ट की जो इनकम है वही
हाँ
हम इंस्टॉलमेंट पे करने में लगाते हैं।
हाँ जी।
वहां पर 85% हमारा कंप्लीट हो जाता है, जो 85% बसों की इंस्टॉलमेंट देके, तो अब तो मुश्किल बड़ी आएगी सर।
यस सर, वही अब तो इसको एक स्टैंड अलोन बिजनेस की तरह देखा जाएगा।
तो
दैट
फिर
इज,
ये
और
एप्लीकेशन,
एक, क्योंकि बिकॉज 11(4)(a), आई जस्ट, फिर भी गौरव सर एक बार मुझे विनोद सर का
सोमिल जी, मेरे ख्याल
नंबर
से
भेज दीजिएगा।
सर का क्वेश्चन शायद 1023C से रिलेटेड है।
नहीं, एक बार कंफर्म कर लेता हूँ सर,
थ्री
विनोद सर।
एडी सर।
हाँ,
नहीं
1023
नहीं
380। अच्छा,
380 सर, मतलब
एजुकेट 1023
380
1023 सी।
एजुकेशन है।
ठीक है, ठीक है। तो सर वो तो हमारी एक्टिविटीज आर हैव बीन हेल्ड एट इंसिडेंटल, सिर्फ सेपरेट बुक्स मेंटेन करनी है।
हाँ,
अब उसमें इनको इंसिडेंटल होल्ड किया है, आई जस्ट चेक, क्योंकि इस एग्जामिशन तो मिलेगी, तो सर वो जो हम पेमेंट्स कर रहे हैं वो तो एज एप्लीकेशन मिलेगा।
मिलेगा।
यस, कैपिटल कॉस्ट विल नॉट बी अलाउड जब आप लेते हैं, लेकिन रीपेमेंट विल बी अलाउड। दोनों चीज नहीं मिल सकती ना सर, वो तो आ ही गया था
नहीं
डेप्रिसिएशन
सर,
और।
एट द टाइम ऑफ कैपिटल एक्सपेंडिचर वी उसको हम सोर्स ऑफ इनकम में ले लेते हैं कि इट
हाँ
इज
जी,
अवर सोर्स ऑफ इनकम,
हाँ
एंड
जी।
एट द टाइम ऑफ रीपेमेंट ऑफ इंस्टॉलमेंट वी टेक इट इन एप्लीकेशन ऑफ फंड्स। तो
हाँ,
नाउ व्हाट
अगर
इज द,
तो सर अभी अभी रिसेंट प्रोवाइजोस और भी ऐड हुए हैं। अभी लेटेस्ट अमेंडमेंट भी आई थी इन रिस्पेक्ट ऑफ द रीपेमेंट ऑफ लोन्स आल्सो। तो एज फार एज रीपेमेंट ऑफ लोन इज कंसर्न्ड, दैट इज एप्लीकेशन।
ओके,
सो नाउ
वेदर
स्टिल
सर,
गौरव भाई
हाँ
मुझे एक
जी,
बार नंबर जरूर शेयर कर देना सर का,
मैं कर दूंगा, मैं कर
क्योंकि 24 प्रोवाइजोस हैं। तो जस्ट इन केस आई डबल चेक, और कुछ होगा तो आई अपडेट यू इन व्यू ऑफ द
दूंगा।
लेटेस्ट
सो
प्रोविजन।
लेट्स मूव ऑन टू द अनदर क्वेश्चन। आशीष जी का क्वेश्चन था।
मगर गौरव गौरव गौरव, एक क्वेश्चन जो मेरे को सोमिल के आंसर से पता लग रहा है कि
यस सर।
इनसे पूछो कि खरीदी थी, चाहे लोन लेके खरीदी थी, तब एप्लीकेशन में तो नहीं ऐड कर दी थी? अगर उस वक्त
हाँ
एप्लीकेशन में लिया तो रीपेमेंट में दोबारा कैसे ले लेंगे?
हाँ, वो एक ही बार मिलेगा विनोद सर। जब आपने सोर्स में ऐड किया था लोन को, और उसके अगेंस्ट क्या जब कॉस्ट इनकर करी थी, पूरा पूरा एप्लीकेशन भी ले लिया था बसेस का परचेज, कैपिटल इन्वेस्टमेंट। सर आप म्यूट पे हैं, विनोद सर म्यूट पे हैं, आप म्यूट पे हैं।
सर उसको एप्लीकेशन में लिया था उस वक्त,
तो सर
जो
प्रीपेमेंट नहीं
परचेज
मिलेगा।
कैपिटल कॉस्ट थी उसको।
एग्जैक्टली।
ओके,
अगर आपने दोनों
ठीक
साइड
है, तो
ऑलरेडी
वन
ले
टाइम
लिया
मिल
है,
जाएगा।
एक ही बार मिलेगा सर।
ओके ओके ओके
और यही अमेंडमेंट आ
ओके।
चुकी है, और अब तो आगे से एप्लीकेशन नहीं मिलेगा, वो मिलेगा तो सिर्फ रीपेमेंट मिलेगा।
नहीं सर, जो
हाँ
जब, नहीं सर, लोन हमने रेज किया जब, उसको
जी,
सोर्स में ले लिया,
हाँ जी।
बसेज की कॉस्ट को हमने एप्लीकेशन में ले लिया। अब जो लोन की रीपेमेंट कर रहे हैं तो वो तो एप्लीकेशन में मिलेगी हमें,
तो
लोन तो कम हो रहा है ना।
फिर तो आपने दोनों चीजों को नेट ऑफ कर दिया ना एक तरीके से, फिर मिल जाएगी आपको रीपेमेंट।
सर मैं
अगर यू आर,
हाँ जी,
अगर दोनों चीजें
रिश्ते
आपने
में,
डेबिट क्रेडिट की हुई है, फिर तो उसका इफेक्ट ही नहीं है ना एप्लीकेशन पे सर।
बिल्कुल जी, बिल्कुल।
सो लेट्स मूव फॉरवर्ड, और भी क्वेश्चन है
मतलब
सर
पॉइंट
हमारे पास।
ओनली इज कि एप्लीकेशन एक ही बार मिलेगी सर।
ओके जी,
एक्चुअल
ओके,
अमाउंट
थैंक यू सर,
एक्चुअल
थैंक
अमाउंट
सर
स्पेंट लेना चाहिए था सर, एक्चुअल अमाउंट स्पेंट लेना चाहिए था एप्लीकेशन में जब आपने परचेज की थी। एट दैट टाइम यू शुड हैव टेकन एक्चुअल अमाउंट स्पेंट, नॉट द इंटायर अमाउंट, परचेज अमाउंट।
सो लेट्स मूव फॉरवर्ड।
यस गौरव भाई।
इंटरेस्टिंग टॉपिक है सर। एक सोमिल भाई, एक क्वेश्चन यूट्यूब पे आया है
हाँ जी
संदीप जी का। व्हाट इफ गुरुद्वारा इज रनिंग अ स्कूल? गुरुद्वारा जो है वो दे आर रनिंग अ स्कूल, देन व्हाट विल हैपन?
सर, क्वेश्चन मेरा ये है कि 11-12 की बात कर रहे हैं, 10-23 की बात कर रहे हैं? क्योंकि 6 में तो गुरुद्वारा स्कूल रन करेंगे, तो सिर्फ एजुकेशन ही कर रहे हैं क्या? वो तो नहीं होगा, तो मोस्ट लाइकली 11-12 की बात होगी।
उस
गौरव
पर
भाई,
क्वेश्चन नहीं लिखा हुआ,
हाँ
तो
मेरे
बस ये
ख्याल से
लिखा है
तो
कि व्हाट इफ गुरुद्वारा इज रनिंग अ स्कूल।
हाँ, तो अगर 11-12 में तो वो तो जैसे होगी, मैंने जैसे बताया कि अहमदाबाद डेवलपमेंट जो 215 का है जजमेंट, वो सिर्फ जीपीयूज के लिए है।
डीपीयूज के लिए।
एजुकेशन एक्टिविटी आप जो कैरी आउट कर रहे हैं, बस 11(4)(a) का जो इफेक्ट आया है वो आया है कि जो ट्रांसपोर्टेशन हॉस्टल्स वगैरह हैं, वो आपको सेपरेट बुक्स अब मेंटेन करनी। एजुकेशन इंस्टीट्यूट्स के लिए ये चीजें अब इंपॉर्टेंट होगी,
अनइम्पोर्टेंट।
जो भी आप एक्टिविटीज एंसिलरी कर रहे हैं वो सब सेपरेट बुक्स मेंटेन कर।
अब एक क्वेश्चन है गौरव अग्रवाल जी का, वो पूछते हैं व्हाट विल हैपन टू एजुकेशनल इंस्टीट्यूशंस अंडर सेक्शन 12? should they remove other objects from their memorandum of association? वहां जरूरत नहीं है.
Again, that is in respect to 1023C6, जो कहता है solely for education.
Correct.
यहाँ ऐसा कुछ नहीं है.
Now we have another question from Sachin Agarwal. Thank you, Sachin ji, for sharing your feedback. इनका question ये है, for carrying out girl child education activities, whether Section 8 companies or trust should be incorporated by a person in lieu of the latest judgment. मतलब companies Section 8 companies incorporate करा लें instead of trust या कैसे करें? Maybe not a right.
मतलब not the subject for today in any case,
Not
but जो education 11-12 पे कोई effect नहीं except for 11-4 है. जो effect है 1023-6 का है, तो वो person तो कोई भी covered है. बात तो आपको conditions पूरी करनी है आपकी activities की.
Correct. So now, if any one of you has any question, quick, we may take a couple of more questions and then we may wind up. If आपका कोई question है, you may please raise your hand. Somil bhai is here with us. We can take up the question. मैं उम्मीद करता हूँ आज का session आपको अच्छा लगा होगा. If you are on YouTube, kindly like and share the recordings of the session with your friends. और सर मेरी एक और रिक्वेस्ट है, मेरे पास ना पर्सनल मैसेजेस बहुत आते हैं कि गौरव सेशन बहुत अच्छा था, वी रियली लाइक दिस सेशन, बट वो मेरी कंजम्पशन के लिए हो जाता है. मेरा सजेशन ये है, आपको अच्छा लगा खराब लगा, शेयर इट ऑन यूट्यूब. आई एम ओपन फॉर ऑल द क्रिटिसिज्म. इट शुड बी ओपन. वी आर डूइंग इट ऑन अ पब्लिक प्लेटफॉर्म. अच्छा लगे तो भी यूट्यूब पे डालिए.
Gaurav ji, are you hearing me?
Yes sir, yes sir.
So my question is that one is the charitable institutions which is implementing the CSR projects of the various companies. So that institution has very technically and qualified people, and if they get some consultancy work also, and they charge for the consultancy, so can that be done by that charitable institution? And what about the GST also, whether they should take GST if they do the provide the consultancy business related to agriculture and dairy farming?
Sir, CSR activities, I believe, I understand GPU activities में cover हो जाएगा आपका. And since you are in GPU, consultancy activity can be done, but again, 11.4A and the proviso limit, 20% of the total receipts has to be adhered to. Baki GST and all those requirements, obviously how a business has to be run, the same concept will apply.
Okay.
Yes, sir.
Thank you, Vijendra ji, for joining and asking your question. Do we have any other question? Thank you, everyone.
In fact, Gaurav bhai, these two judgments, the more you read, and especially the Ahmedabad development and all the two judgments, the more you read, and if you try and compare them together or go together with them, the more confusion it can create.
Absolutely.
So, and these two judgments are still new. We all have our own interpretations. And in times to come, we have seen Fernandez Foundation. Sir, GPU is General Public Utility, sir. Advancement, जो हमारा last limb है 215 का, General Public Utility. So these judgments have thrown severe interpretations and have laid down, and they have dissented from the law which was settled, and how we are yet to see how things unfold, especially in lines that law declared is prospective. Now how it will be applied is in the womb of the future.
Somilji, one thing more I would like to ask from you.
Yes,
is
sir,
that
please.
most of the institutions who are implementing the CSR projects,
Yes, sir.
they are all 99% are taking as the not other activities, rather they are taking it as the main donation, and they are filing the Form 10BD also for that. And the CSR companies, they are also taking as the donation receipt there. But I don't know how it is being done, but because you say that it is other activity, it cannot be taken as the donation, main donation, the institution. What is your viewpoint regarding this? Can it be regarded as the donation or the receipt from the other object, the incidental object?
Sir, the way GPU has been defined in exam, because other limbs of 215 are quite specific: medical, relief for poor, education, environment, yoga, they are very specific. So if at all any activity has to fall, it will fall in general public utility. So CSR expenditure, seeing the way the law has been laid down in Ahmedabad Urban Development, that these are for public purposes, to what extent that can be read into is to my mind a litigious issue. But yes, case can be made out that CSR activities, corporate social responsibility are being
Yes.
fulfilled, and they can be read. But if a conservative view has to be taken, it should be better to remain in incidental activities, and separate books should be maintained to keep it a little away from litigation.
Okay. Okay. Thank you.
Yes, sir. Sir, charitable institutions are under severe lenses. So it is now becoming a norm that what you want to, if you want to do charity, then do charity, please. Whatever business you can want to do it and pay taxes.
I have received one personal WhatsApp from Mukesh Mittalji,
Yes, Gaurav.
and I'm not the expert on charitable trust, not on the income tax. उनका suggestion है या comment है वो मैं share कर लेता हूँ. He's saying play school is eligible under section 11 for trust which are registered under section 12A, the trust which are educational trust. Second, his point is every institution having more than 5 crore receipts must go for registration under section 12A and not for 1023(6).
Yes. Sir, the point is 1026 is becoming very narrow, and the way it has been interpreted and solely and not for profit, it will be a tight compartment as compared to 11 and 12. और सर मैं तो ये मानता हूँ कि मतलब ये प्रोविजन है भी क्यों, 24 प्रोवाइजो तो हो चुके हैं, एक सेक्शन ही चेंज कर दें. ये 11-12 में कर लो जो करना है.
Thank you, Mukesh ji. If you are listening to this, I am grateful to you for sharing your comment. Thanks, Somil bhai. Thanks for the wonderful session. And एक जो confusion था उसको clear करने के लिए, hats off to you. It was creating a lot of confusion in everyone's mind. मेरी आप सबसे request है आप ऐसे ही जुड़े रहें. Whenever we do session, do join live or on the YouTube, and do share link of my YouTube channel or this session with your friends so that the knowledge can reach to maximum of our tax professionals. Thank you.
Okay. Thank you, Gaurav ji. Thank you so much.
Thank you, sir.
Thank you,
Gaurav ji.
Wishing all of you a very happy new year, क्योंकि अब जो next session होगा वो 31st के बाद ही होगा, तो आज से ही आप सबको happy new year और सर्दियों की शुभकामनाएं. Thank you, Somil bhai. Once again, thank you for joining.
Thank you, Gaurav bhai. Thank you.